Wonderful Alex Barthet, a Florida construction lien law expert. Today's webinar topic is Stop! Don't sign that release unless it says this. So without further ado, I'd like to introduce the fabulous Alex Barthet.
Thanks, Jesse. My name is Alex Barthet. I am a board certified construction attorney here in Florida. And today we're going to talk about releases. We're going to go over the basics of releases, but then we're going to talk about one really important thing that you need to make sure you look for and understand in every release that you sign going forward. So if you have any questions, use the GoToWebinar chat box, which should be on your screen. We'll answer all the questions at the end. Please make sure not to include the names of any people or companies in your questions. Okay, what are we going to go over specifically? We're going to talk about releases. We're going to look at the Florida statutory 713.20 releases, and then a different release that is a little more broad. I'll explain all its parts and pieces so you understand how it works. I'm going to explain the one thing that you have to make sure you do with every release. We'll talk about conditional releases. There's some questions about those, how they work and what they are. I'll give you some tips and tricks. And then of course we'll answer any questions, and I will go over some resources during the presentation, and at the end we'll go over some SunRay resources to make your job easier. So let's get right into it. Let's take a look at some releases and the various forms that they come in. So the first thing you need to understand is a release is a contract document. It has legal impact. If you sign it, it will have significant legal effect on your right to collect money and on the project. But what it says and how it's written and what's good for you and bad for you depends on where you are in the process of this release, right? So it depends if you're a GC or a sub or a sub-sub. So as a subcontractor, you want to give the narrowest release when you get a check. So if I'm a sub and someone is handing me a check, I want to give away the fewest amount of rights as possible to preserve rights that I may want to assert later, right? So if I'm getting a check and I'm giving a release, I want to give the fewest amount of rights as possible. Now, if we look at a GC, it's in reverse. The GC wants to get a broad release when it gives a check. So when a GC hands you a check as a sub, they want to know that once you sign this release, you're never going to come back to them for anything ever. Now, remember, I'm using examples of subs and GCs, but everyone in most instances sits in both places, right? So if you're a sub and a GC is paying you, you want to give away the fewest amount of rights when you get a check from a GC. But if you have a sub-sub that you've hired, it's the reverse. You want to give that sub-sub a check, but you want to make sure that when you get that release from the subcontractor, that they give away as many rights as possible. So again, keep this in mind, not just from your position looking up in the chain of contracts, but also your position looking down in the chain of contracts. All right, so let's take a look at what would be considered the most standard forms of releases, and that's those found in Chapter 713.20 in Florida. So this is the standard statutory waiver and release of lien upon progress payment. So let's read it so we all understand its parts. The undersigned, in consideration of the sum of some amount of money, hereby waives and releases its lien and right to claim a lien for labor, services, or materials furnished through, you'll insert a date, 2, you'll insert the name of your customer, on the job of, you'll insert the name of the owner of the project, to the following property, and then you'll put the property description, whether that's the address and or a legal description. And then it goes on to say that this waiver and release does not cover any retention or labor, services, or materials furnished after the date specified. The date specified is that through date, where it says insert date, that's the date we're talking about. That's the through date. So this release releases your lien rights, and we'll talk about other rights you may have. This releases your lien rights through that date certain. All right, so this is the progress payment release. Let's take a look at the final payment statutory form of release. The undersigned, in consideration of the final payment in the amount of blank, hereby waives and releases its lien and right to claim a lien for labor, services, or materials furnished to, insert the name of your customer, on the job of, insert the name of the owner, to the following described property. And you'll insert the property address or legal description, and you'll sign and you'll date it. Now notice that there are two main distinctions between the final release and the partial release. If we go back to the partial, you'll notice that it has that last sentence where it says this waiver and release does not cover retention or materials or labor services after the date specified, right? So that has now been removed, right? Because it's your final release. This is the last release you're giving. This is the last check you're getting. There is no more retention. You're not doing any work after this date. So that sentence goes away. The other major difference is it has no through date. If we go back and look at the final release, you'll notice that it has no through date in the body of the release. And the reason is that the final release is effective as of the day you sign it. The partial release has two dates on it. It has the day you sign it, but it has the through date in the body of the release. So for example, I can sign a release today and I can release my lien rights through the end of January, right? 3 months ago. And that the end of January is the through date, even though I may sign it today, right? So that's the distinction of why the progress payment release has a through date and a signature date, and the final does not. So if you sign a release that has no through date in it, it's effective as of the day you sign it. So be very careful. All right, so let's take a look at this other form of release. So the first thing you notice is it has a lot more words. This is not a statutory release. This is a custom release. Let's go through it and I'll explain its parts and pieces. So it says the undersigned, in consideration of the sum of $10 for other good and valid and other good and valuable consideration, does hereby waive and release its lien and right to claim a lien. If we stop there, that's what the statutory release only your lien rights. This is releasing a lot more because it goes on to say that you're releasing any and all claims, change orders, works, materials, delays, fees, costs, losses, expenses, damages, or sums for labor, services, or materials furnished, right? So not only does this release your lien rights, it releases any claim you have, including change orders, or costs or fees or delays. So this is a blanket release. If you sign this release, you're giving up all of those rights. And when are you giving them up through? This one has a through date. So this is a release through the date of, and it has the blank and it says through date. So understand that if you sign a release that has much broader language, you are in fact releasing not only your lien rights, but lots of other rights, right? So when we talked about the idea that as a general contractor with my subs, I want to get from them a broad release, this is what I'm talking about. When I said as a sub, I want to give away the fewest amount of release rights as possible, that's the statutory form, right? The statutory form gives up the least amount of rights possible. Now, what's interesting is when you look at other releases that are handed to you to sign, they probably have lots of other words and things that you're representing and possibly releasing. So this one says, the undersigned warrants and represents that it's paid all its bills and its suppliers and employees. And it says the undersigned further warrants that all work complies with the applicable contract documents. So understand that when there are lots of words in the release, they're usually trying to make you sign away lots of rights and affirm lots of things in the course of signing the release. Again, so be very mindful of what you're signing. So if you agree to a form of release in your contract, or the contract says a form acceptable by the GC or owner, you may be bound to use that form. Because a question we get all the time is, okay, Alex, this is great. how do I avoid having to sign a release that I'm not comfortable with? And the answer is you need to look at your contract and you need to negotiate the form of release when you sign the contract. So if someone is handing you their contract form and you have to sign it, you need to not only review the price, scope, schedule, you need to review its terms and conditions, including the exhibits. And in many instances, when someone hands you a contract to sign, it's going to have sample releases that it's going to say, these are the release forms you have to use every time you request a payment. Those forms are likely the broad form release, the ones with lots of words. So you need to negotiate that at the time of contract. So what are ways that you can do that? Well, the easiest way is to add language to the contract like the following. The parties agree that Florida Statute Chapter 713.20 forms of releases shall be used for all partial and final release forms. They will be conditioned upon payment. We'll talk about that in a minute. And subcontractor may include exceptions in the release. So if there's one thing that you can do to modify your contract, by the way, as a GC with an owner, as a sub with a GC, as a sub with a sub, again, this is looking up in the chain of contracts. By adding a sentence like this, you now have the right to, one, change the forms of release to a release that's less problematic for you if you're the one having to sign the release. You're going to make it conditioned on payment. We're going to talk about why that's important in a minute. And you're going to include the ability to include exceptions in the release. So for example, maybe you need to carve out a claim. Maybe you have a delay claim or an extra work claim or unexecuted change orders that you want to remove from the release, right? You don't want to release those rights until that change order has been signed or that claim has been approved. The way to do that is obviously to timely submit the claim, but you cannot sign a release that gives away that right and then expect that right to exist later. So you need to exclude it from the release every time you sign a release. So this is the first tool that we have. It's completely free. It's called the Lien-O-Matic. If you go to lienomatic.com, fill in your information and we'll send it to you. It is a handy desk tool that summarizes the lien law based on your role on the job. So if you go to the website, it'll have a little video of how this works. And again, put in your information. We'll mail it out to you for free. You'll get it in about a week. And it's a great way to have a simple understanding of the lien law on your desk all the time in case you have any questions. All right, so what is the one thing you need to do with every release? You need to match the through date with the amount of money you're getting. And let me explain what that means. The through date is the effective date of the release. It's not necessarily the day you sign it, unless, of course, the day you sign it is the only date on the document wherein it has no through date. But I'm assuming we're talking about releases that in the body of the document have a through date. The through date will control over the payment amount. Let me give you a very specific example. You submit a pay request for the month of March for $10,000. You show up to pick up your check for $10,000 and it's only $8,000. Now your pay request says $10,000. The check that you're about to pick up says $8,000. The release says that it's through the end of the month of March. If you sign that release through the end of March, you pick up that $8,000 check. You have given up legally your right to that $2,000 difference. Many people think, well, I only got $8,000, I didn't get $10,000, so therefore that extra $2,000 will just roll into the next pay period. That is not true, because when you sign a release that says that you have received some amount of money through a through date, again, the end of the month, legally what you're saying is, I have received money to be paid in full through the through date, even though your pay request may have been for more money. So If the through date and the payment amount don't match, you need to change one or both so that they do match. So let's take this example again. You show up, you submit a $10,000 pay request that is supposed to get you through the end of March. You show up to pick up a check and it's only $8,000. So one of the things you can do is change the through date. Maybe $8,000 isn't the end of March. Maybe it's the 24th of March. Maybe it's the 17th of March. You have to figure that out, and you want to change the through date to match the dollars that you are getting. Alternatively, you can include an exception, or to carve out that $2,000, or you need to collect the extra $2,000. You cannot accept $8,000 to get you to the end of the month if in fact $10,000 is what you're owed for the end of the month. All right, so let's talk about conditional releases because they come up very often. So a conditional release is a release that is expressly conditioned upon payment. You use it when you do not have the money in your hand at the time that you have to sign and give someone the release. So here's some language that you can use, and I'm going to show you a tool to make your life much easier here in a minute. Notwithstanding anything to the contrary, this waiver and release is conditioned upon and not effective until the undersigned receives paid funds of blank. So if you're expecting a $10,000 check, you're going to write this on the release and you're going to add $10,000 in that blank. And what does that mean? That means that the release that you're handing someone based on the promise that they're going to pay you $10,000, that release is not effective until you actually receive those $10,000 in paid funds. You need to use conditional language whenever you're handing someone a release and you're not getting paid immediately. So let me give you some examples of what that means, right? That means someone emails you a copy of a check and they say, look, here's the check. And they say, email me a copy of your release. Well, if you email them a copy of your release and it doesn't have conditional language, that release may be effective even though you never got the check. If someone gives you a check and you're concerned that that check may bounce or they may put a stop payment on it, you want to add conditional language. Because if they hand you a check and the release is not conditioned on the clearance of those funds, then you will have given up your lien rights. Now, I want to be clear, you still may have legal recourse against the person that gave you the bad check or promised to pay you and never paid you. That's not what we're trying to protect ourselves from. What we're trying to protect ourselves from is that unconditional release, the release without a condition that you hand someone based on the promise of a check or a check that hasn't cleared yet, as that makes its way up the chain of contracts to the owner. Well, guess what? The owner has no reason to know that you got a check that may have bounced, or that you gave the release based on a promise of payment that never arrived. From the owner's perspective, who doesn't know, if they look at your release that is not conditioned on payment, they understand that you've been paid in full. So the legal effect is that if that release without a condition makes its way up to the owner and you don't get your money, you still have legally given away your lien rights, even though you never got paid. So again, it doesn't mean that you can't pursue the person that gave you the bad check. It just means, unfortunately, that you will have given up your lien rights, which are the rights you're trying to hold on to. Watch out for releases that are titled as conditional and they're not. So sometimes we see releases titled conditional partial release of lien, but when you read the document, it has no condition in it. That is not a conditional release. It has to have conditional language in it. Also, you cannot have a $10 conditional release. So if the language that is conditional says that it's conditioned upon you receiving $10, well, if they pay you $10, then the condition's been satisfied. So you want to put in the conditional release the actual amount of money you're expecting. So we have this tool It's called the Make Me Conditional stamp. You can go to makemeconditional.com. We'll send the stamp to you for free. It has that language on it, the language I read to you. It has it on it. So now instead of having to write on every release that the release is conditioned on payment, if you request this stamp, we'll send it to you for free. You now will be able to make every release conditioned by just using the stamp. Go to makemeconditional.com and we'll send it to you for free in about a week. All right, Jesse, we covered a lot. Do we have any questions?
First of all, Alex, as always, you are wonderful. Thank you so much. I do appreciate it. We do have a couple questions that came through, and this one came through just before the end of that last slide that you were showing us. So hopefully you answered this already, but I'll go ahead and ask it as well. The question is, when the form shows $10, is that just a placeholder or a standard amount?
So why does the release say $10? The release says $10 because it is just a placeholder. So I can be the one that is giving you a check for $5,000, $10,000, $500,000, and I want the release to say $10. There are some strategic reasons why people put $10 in the release instead of the actual amount. Our advice generally is if you are giving someone a check and getting a release from them, you'd like the release to say $10 so that you don't have to argue later that they can say, well, I was expecting a $10,000 check and you only gave me an $8,000 check, right? So if the release says $10, the court is generally going to say, well, did you get some money? Yes. Okay, well then we're not going to argue about the fact that you think it should be 10 and they say it was 8. The shoe is on the other foot. However, if you are handing someone a release and getting a check, we typically recommend that in those situations, you scratch out $10 and you put in the amount of the check you're actually expecting, right? So we go back to my $10,000 example. You would scratch out $10 and you would write in 10,000. So that would be, again, it's not technically conditional, but it's a better argument to say, well, I gave this release in expectation of 10,000. You only gave me 8,000. So now we have a legal argument that you didn't get all the money you were expecting. There are some completely valid reasons for $10 releases. The two most common are, one, you didn't do any work during that period, and because you sent a notice to owner, you now need to give someone a release. So that release is going to say $10 because actually you were not owed any money, so they'll usually put $10 there. The other reason is on fixed price contracts between owners and contractors. Contractors sometimes don't want owners to be able to add up how much the contractor is paying to the plumber and the electrician and the roofer. So the contractor only wants the releases to say $10 so that when the release goes all the way up to the owner can't start adding up numbers and realizing that, wait a second, I thought you were paying the plumber $100,000, you're only paying him $60,000. When they add up all the numbers. So that's another reason sometimes people use $10. Any other questions, Jesse?
Yes. It says, can I put the conditional language stamp or handwrite that language onto a release that the GC provides to me that was in my contract, or any release for that matter?
Any release. You can add it to any release. Now, just be aware, some people will say, oh, you can't change my release, I'm not giving you the money. And that's another discussion. That's a much longer discussion about the fact that maybe they can, maybe they can't. It depends on the contract. There is a little line in the lien statute that does say that anyone is entitled to make their release conditioned upon the clearance of funds. So if you cite that, if someone gives you a hard time, that usually can convince them. But that stamp can be used on any release at any time.
Okay, and then I believe this is another follow-up question to the $10. It says, will we be protected though if it says $10 and it's because they don't want the owners seeing the actual amount?
Well, if the question is are they protected? If they are the sub, the question isn't whether or not it says $10. The question is, are you getting the amount of money that you expect for the period that you're releasing? So for example, if you're expecting $10,000 for the period that you're releasing, let's say through the month of March, and you get the $10,000 check, then it doesn't really matter to you that it says $10 or $10,000, because you were expecting 10,000 through the end of March and you got 10,000 through the end of March. So as long as you get the money that you're expecting to receive for that period, then if it says $10 or not, it doesn't really matter to you. It's only if there's an argument about how much you should receive for that period.
I believe they were asking about if that was like on a conditional, but I think you've already answered that it should not say $10 if it's a conditional release.
Correct, and not say $10 for conditional.
I do think that is all the questions that have come in so far. If anyone does think of another question that wasn't addressed, please feel free to reach out and we will be sure to answer any questions at that time. If you guys could, these are some of SunRay's resources that will help you guys stay organized, know your deadlines, and secure your lien rights. So go ahead and scan that QR code to access these incredible resources. Please remember, every state has its own unique lien laws. This webinar was specifically for Florida. So if you are working in another state, please go to our website. You can see what other documents and deadlines are associated for that state. All right, so we have our next webinar with Alex. It's going to be June 18th, 7 common lien and release traps and how to avoid them. And then again on July 16th, I recorded my lien, now what, how do I get paid? We'd love to be able to see you guys there. Please sign up for free at sunraynotice.com/education. All right, and then here we have our in-person seminar. So if you are going to be in the Miami area, Alex is going to be presenting alongside of Ariella for a live.
This one's in Palm Beach.
I'm so sorry that I said the Miami. I apologize. Yes, you are right. This is in Palm Beach. So if you guys are going to be in that area, please, 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 we'd love to be able to see you guys. That's going to be May 21st. You can sign up at sunraynotice.com/seminars. We will have another Miami seminar later in the year. I believe it's in October. But we'd love to see you guys here for this one in Palm Beach. All right. And then here, if you don't mind, give us a quick moment of your time. We'd really appreciate it. Any feedback you guys can provide to us. It helps us always better ourselves and help us get information out to other contractors and suppliers like yourselves. And then the next slide, please. All right, and with that, that is all we have for you guys today. Thank you so much to everybody that attended. We hope to see you at our next webinar. Alex, again, as always, you really are wonderful, so I appreciate you so much. I hope you all have a beautiful and sunny day.